Test. Test.
Oh, so we're getting it through Zoom. If you can, let me see that.
It doesn't look like anyone's logged on Zoom. Do we need it?
I'll mute Zoom on my end so it doesn't play it twice. If no one else is in, they don't need it. So I'll mute it.
Test. 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 All right, it sounds like it's working. All right, meeting of the Planning and Economic Development Committee was held today, Tuesday, November 18th, 2025, at 7:01 p.m. in the Automatic Chamber, and duly noticed in 2 places, including the city's website, in accordance with the requirements of RSA 91A2, Section 2. Will the clerk please call the roll?
Alderman at Large, Melbourne Moran Jr., Chairman.
Here.
Alderman Derek Tebow is here. Alderman Ernest A. Jetty.
Here.
Alderman at Large Ben Clemens.
Here.
Alderman Tyler Govea, Vice Chair.
Here.
We have 5.
Thank
We
you.
also have Matt Sullivan, Community Development Director, and Sam Durfee, Planning Manager, who's on Zoom, I believe.
Is he on there, or?
Yes.
He is, okay. I wonder why I can't. Okay. We're going to open up a public hearing for O-25-073, amending the land use code regarding approved subdivision exemption. Is there any introduction to each of these before we call for testimony? Director Sullivan?
Yes, thank you, Mr. Chair. Matt Sullivan, Community Development Director for the City of Nashua. Manager Durfee and I have prepared some brief comments on each piece of legislation. Perhaps what I can do is just provide a brief overview of why we're here with these 5 pieces of legislation, dive into the first piece, O-25-073, and then we can either go right in a row or happy to allow the public hearing between each piece, subject to your discretion, Mr. Chair.
Yeah, let's just go straight through.
Okay.
That way we can just open up right to the public.
Great. And I did note that the clicker wasn't working for me earlier, so perhaps if the clerk or chair could advance the slides. When we get to, we can stay on the slide for a minute, but unfortunately I couldn't find a way to move the slides along from up here. The first piece of legislation before you this evening, before I jump into that actually, there's a reason why we're here this evening for these 5 pieces of land use legislation. You're well aware that we're underway with our land use code update, the recode effort that Mr. Durfee has been before the committee presenting on for several months. You're also aware that we're doing our best to avoid substantial changes to the land use code while their effort is underway, recognizing that the code will likely not be in place until mid-2026. But the 5 pieces of legislation before you this evening are actually initiated completely at the state level through legislature changes over the last 2 years, with 4 of these amendments being the result of 2025 legislative actions at the state level and 1 being the result of a 2024 effort. And so with the exception of a few small items tonight, few small items within the 5 pieces of legislation, all of these changes are well prescribed by state legislative actions. And I'll talk about what those exceptions are as we go through the items this evening. I did just want to quickly note the text in italics there. And that is to say that these 5 pieces of legislation are not the only changes to how we apply our land use code based on recent state legislative actions. One example being HB 631 that changed how certain uses are allowed in different zones. But these are the 5 that required immediate action on our behalf because of their effective date and immediate changes that were needed to our ordinances in order to comply with the state law changes. So Mr. Clerk and Mr. Chair, if you wouldn't mind going to the next slide, I'm happy to jump into the first one. And Manager Durfee, who's on as well, will cover any of the gaps in my knowledge. He and his team directly developed the language that you see before you, but we'll fill in any gaps that might arise during certainly our overview and then during the public hearing and the committee meeting. The first change to O-25-73 is a modification to what's referred broadly as the vesting statute. Currently within the city's land use code, when applying for a subdivision, if an applicant is granted an approval, their approval lasts for a period of 5 years. Their approval is vested from changes in land use regulations for a period of 5 years. They get that 5-year vesting or protection from changes only if they complete what we refer to as active and substantial development within 24 months of the approval. So if you receive your approval today, within 24 months of today, you have to complete active and substantial development. And if you do that, you get 5 years of protection from changes to the land use code or other regulations that would impact your proposal. If, of course, you don't complete active and substantial development or you don't complete the work within 5 years, you'd be subject to changes to the regulations and the ordinances and would have to come back before the planning board or any other applicable board in order to comply. But the change that happened recently is that those deadlines have been extended. State statute now mandates that we provide applicants or approved developments with 3 years for active and substantial development, and then 7 years is granted to them should they achieve active and substantial development within that 3-year initial window. Like many of the proposals before you this evening, there are some challenges with this. I think these state changes were well intended, but ultimately this will provide more time for a given development proposal to move forward. So applicants or approved applications will have more time to actually go forth and finish their work and more resilient to perhaps to changing market conditions that happen after their approval. One of the other interesting features of this is typically we look forward when we implement a land use change like this, and it impacts only proposals that happen in the future. This piece of legislation was interesting because it actually was very explicit about the fact that any approvals that had happened as of July 1st, 2023, so going back in time, would now be subject to this. So there's actually a retroactive impact where had the planning board approved a subdivision on August 1st of 2023, they would be given the 3-year active and substantial allowance and then the 7-year protection under the ordinances should they achieve active and substantial development. I realize this is a relatively technical concept, one that staff deal with quite a bit, and certainly our planning board does as well, but one that we are, again, required to implement here in the city as a result of the state level changes. Happy to answer any questions during the committee meeting or address any public comments that might arise.
If we can hold the questions to the committee.
Great. And I'm happy to go into the next change if you'd like. This is the one product of a 2024 action. This was 2024 HB 1567 that dealt with was really focused on the creation of more opportunity for child care facilities and removing some of the barriers to creating small home-based child care facilities around the state of New Hampshire. And what it functionally required is that municipalities allow child care facilities within dwelling units by right, that they're permitted without any additional zoning action being necessary, provided that those child care facilities met all the requirements of DHHS Administrative Code under HEC 4002. If you have questions that are specific to that section of the administrative rules, I can absolutely pull that up this evening and try to answer those. But generally, these child care facilities have to be accessory to the residential use on site. But the idea is to allow more small child care facilities. So there are a few things that we had to do to bring our zoning ordinance into compliance. One, within our use table that you may have seen, it has hundreds of uses. You've talked about this at your prior PEDC meetings. We specifically made an amendment to allow use number 241, which is daycare family, as an accessory permitted use within all residential zones. So this is the use that most clearly aligns with the change that was made at the statutory level. So what we've done is we've made it permitted in all the appropriate zoning districts as an accessory use. Further, within our major home occupation section of the ordinance, we've made some changes to remove size restrictions that existed within that section 19047. And you can see this within the language that you have before you this evening. And then finally, not specific to the change that happened at the state level, but we actually had some content-based signage regulation for home occupations. That's something that was actually, it was made illegal several years ago by a different Supreme Court action. We've taken out those content-based regulations as well, just as a matter of cleaning up the ordinance to make sure that it's legally compliant. But again, the goal here is to make home-based childcare facilities permitted in all residential zones when accessory to residential uses, and I believe we've done that. Happy to go into the next change. 025-074, this is relative, or rather 75, and this is relative to on-site parking requirements. This has gotten a great deal of press over the last year. What this essentially did under SB 284 is it prohibited municipal zoning ordinances from requiring more than one parking space per unit. And when we refer to a unit here in the city of Nashua, we're talking about several different housing typologies: accessory dwelling units, duplex dwelling units, single-family dwelling units, multifamily units, and modular homes. So for any one of those housing types, for every unit, the city cannot require more than one parking space. In some sections of the code, as you'll see in the amendment, we required 1.5 spaces. We had some other requirements as well, but those have essentially all been leveled out to be one space per unit across the board. And again, we have no ability to really change that. And honestly, I think for the city of Nashua, this already aligns pretty well with a lot of our goals when it comes to parking, particularly in our downtown core. So I put this last bullet in just to remind folks that at least in our current zoning code, where there are sections of the city where no parking is required, this doesn't change that at all. Again, no parking will be required. We just can't require more than one space for each dwelling unit that's created. And happy to answer any questions or address public comments as they may arise. Moving on to perhaps the piece of legislation that received the most public attention. This is HB 577 relative to accessory dwelling units. This was made effective, as many of these were earlier this year, so it's been in effect for quite some time. This changed several of the parameters around accessory dwelling units and their, how they can be treated by zoning ordinances across the state of New Hampshire. There are a few sort of critical changes that I wanted to highlight here before we get into the changes that are proposed in our ordinance. One critical thing is that there was a change to not only do municipalities have to allow accessory dwelling units in an attached form, but you now have to actually allow detached accessory dwelling unit while still having the ability to restrict it to one accessory dwelling unit per property. Further, for all accessory dwelling units, whether detached or attached, they must be allowed by right. Therefore, a municipality cannot require a special exception or a conditional use permit. Our current ordinance contemplated that each ADU required a special exception from our zoning board of adjustment. It was an additional permitting process requiring applicants to meet several conditions in order to get a permit, being subject to a public hearing and a abutter notification. That requirement is functionally wiped out, and we'll get back to that in just a second here. One other thing that the language modification was really clear about at the state level is that ADUs shall be allowed without any additional requirements that were specific to ADUs relative to lot coverage, setbacks, aesthetics. So basically, if you're doing an accessory dwelling unit, a municipality cannot choose to apply other dimensional or other standards simply because you're doing an accessory dwelling unit. Sort of an interesting stand taken by the legislature here to really say that there shall be no different treatment of ADUs than any other dwelling unit. And so I think they were explicitly clear. So when it comes to the changes that we're making in our ordinance, if we could perhaps go to the next slide, we're really just mirroring these conditions that exist within the new statute. Of course, they're all accessory dwelling units, provided they meet certain conditions that we've laid out, are by right and do not require zoning relief from the zoning board via special exception. They may be detached or attached. Just to be clear, we've maintained a one accessory dwelling unit per primary dwelling unit standard, so you can't have multiple accessory dwelling units in our proposed ordinance. One thing that I know, one of the committee members grabbed me before the meeting to ask a great question about our maximum ADU size increasing from 750 to 980 square feet. I know Manager Durfee's on. He can explain a little bit how we got to that 980 square feet, because that's one of the few items this evening where we have gone above and beyond what the statute calls for. The statute called for a 950 maximum. We've actually gone above and beyond that, allowing up to 980 square feet for either detached or attached accessory dwelling units. And we can talk a little bit about how we got to that number. One carve out is for if you are creating an attached accessory dwelling unit within an existing structure, provided that you're not expanding the existing structure to build the ADU, you can actually have an accessory dwelling unit up to 1,200 square feet. So again, you have an existing building permit, an existing structure. You can create an ADU provided that that ADU does not result in structural expansion up to 1,200 square feet in size. So that's sort of the first slide on the changes that we're making.
Director Sullivan,
Please,
would
yes.
an example of that be a garage that's turned into like a room of
Yes,
some
it could.
kind? Okay.
Well, it would have to be an attached accessory dwelling
An
unit.
attached garage.
So that could, yes, that absolutely could, yes. If it were an attached structure, certainly that would qualify, yes.
Okay, thank you.
And if we could just go to the next slide very briefly, I wanted to comment on a few other changes that we're making, again, very much in alignment with the statutory changes. We've removed some of the aesthetic or design considerations that we had in our current ordinance. We're no longer able to require these because the statute is now clear that you cannot have unique design review requirements related to accessory dwelling units. So we had some clear standards in our current ordinance that we now need to take out. We've made it clear that 1 parking space is required per ADU in alignment with the previous change that we talked about. But that space can either be provided on-site or can be provided off-site if there's a permanent, or rather there's a dedicated parking space for the ADU, whether that's on an adjacent property or on the property itself. So we're providing some flexibility there. One thing to be clear about is the ADUs are not permitted as accessory to multifamily housing units. So if you have a 4 or 5 bedroom multifamily building, you can't add a unit as an accessory dwelling unit. That's a different, there'd be a different zoning interpretation applied to that. It can only be to really single family dwelling units in that format. We haven't taken away the requirement for a covenant. One thing we have changed is that the covenant and fees have to be paid prior to the building permit for the ADU rather than prior to the CO being granted. We've actually accelerated the need for the covenant to be recorded. And that covenant, all it does is it says, I'm aware of the ADU restrictions, I'm aware of the rules, I'm going to comply with them, and so we've always kept that as part of our ordinance and intend to do that moving forward. And then finally, we are asking, because the statute allows us to, for proof that adequate water and sewer supply exists. So if you're creating an ADU, your existing water, sewer service or sewer service have to be proven to be adequate. So if you have an issue that needs to be addressed, you're required to address that prior to adding additional dwelling unit demand. That's a summary of the changes that we're proposing to make within the ADU amendment. And then finally, an interesting one, and particularly interesting in the context of several conversations that have happened in this committee and elsewhere. We had several debates over recent years about unrelated individuals and occupancy limitations. You may recall that we had gone back and forth about whether to introduce new occupancy requirements, particularly in the context of recovery housing. We had had some pretty substantial committee debates. The state has, I don't want to say taking care of this issue because I think it depends how you feel about unrelated occupancy thresholds. But the state has made it very clear, as I've bold, underlined, italicized there, not to overdo it, that zoning ordinances that are based on familial or non-familial relationships, marital status, occupation, employment status, or educational status shall not be enforced. We cannot enforce any ordinances that do that. If you recall, within our ordinance, Table 16.1, which you'll see in the zoning change before you, does exactly that. It regulates households based on whether they're related or not. So how have we rectified this? We've taken Table 16.1 out. There are no longer any limitations on unrelated occupancy within our zoning ordinance because we frankly don't have the legal right to regulate that way any longer. I expect there could be some conversation this evening about, in a future change, whether we should add occupancy limitations. Either Manager Durfee or myself can speak to that. It's beware of the unintended consequence kind of thing, where because you can't regulate household size or occupancy based on whether it's a family or non-familial relationship, it could have substantial unintended consequences when you have families that are non-traditional or required to occupy smaller spaces. There may be cultural differences. I think I'm being clear here with what my message is. We really would need to understand if there's any conversation about trying to limit occupancy with any types of dwelling units in the city. We would have to do a really clear and full analysis to understand what the implications of those changes would be. And as a result, we've proposed to remove any occupancy standards that exist in the ordinance. Happy to answer any questions from the committee or address those from the public as well.
On that last one, I just want to note before the public hearing that my colleague from Ward 6 had reached out to me to ask why this, because it's almost the opposite of what he had proposed.
Yes.
And because he saw my name come on the legislation, and I said, state mandate, we're just updating.
Yeah.
It's not a direct result of some kind of back and forth on what we consider right on this particular ordinance. The state's decided for us.
Absolutely. I agree. Yes.
All right, thank you.
Thank you.
All right, so I'll start the public hearing in order. 025-073, amending the land use code regarding approved subdivision exemption. Anyone testimony in favor, please state your name and address for the record. Seeing none, testimony in opposition. Seeing none, again, testimony in favor. And testimony in opposition. Seeing none, I will declare the public hearing on 025-073 closed at 7:21 p.m. And I will open the public hearing on 025-074 at 7:21 p.m., amending the land use code regarding family daycare facilities. Any member of the public testimony in favor, please come up to the microphone. In opposition? Seeing none, in favor? Seeing none, in opposition? Seeing none, I will declare the public hearing of 025-074 closed at 7:22 p.m. and open the public hearing for 025-075 at 7:22 p.m. Amending the land use code regarding on-site parking requirements for residential uses. Testimony in favor? Seeing none. Testimony in opposition? Seeing none. Testimony in favor? Seeing none. Testimony in opposition? And none. The public hearing on 025-075 was declared closed at 7:22 p.m., and I'll open the public hearing for 025-076 at 7:22 p.m., amending the land use code by amending the accessory dwelling unit ordinance and definition of dwelling unit accessory. Any testimony in favor? Testimony in opposition? Your name and address for the record, please.
My name is Dan Richardson, live at 70 Berkeley Street, Nashua, New Hampshire. I come in opposition to 02576. These two ordinances, this along with 77, are intent on destroying some of the better qualities of Nashua. And, excuse me, I have to wear double glasses because a single prescription doesn't work for me
Take your time.
anymore. Back in the 1990s and 2000, it is well known that there were a number of folks that came from Massachusetts and did what's known as property flipping. That's where they purchase a property which is perceived to be undervalued. They give it modest or minor improvements, and then they resell it for a higher value. That is something that could come back to bite us with these ADUs, which, if you take the better parts of Nashua, which are the properties with the larger lots, and they start adding ADUs in them, creating rental areas. They're called ADUs, but they can be used for rental purposes. Flipping those, eventually, after having put in ADUs on otherwise previously the better parts of Nashua, larger lots, and it's inviting a great deal of damage to the city, to the character of the city. And from the prior gentleman, the staff person who talked about setbacks, and my interpretation from what he said is that setbacks do not apply for these ADUs. I could be wrong. It'd be great for him to clarify that. But setbacks are very important, and the intrusion in the setbacks are only in the event that there is a hardship for the primary residents currently. For ADUs, allowing them into a setback would be devastating. His material also said that there's a limitation of 1 ADU, and I'm not terribly sure that that is accurate. Looking at the 076 changes, the very first one talks about changing the limitation on the number of square feet for the ADU from 750 to 980. Now, you have to recognize, you take the square root of that and assume a square property. That's the way of figuring. That's a 35 by 35 footprint for a single family, for a single level house. That is the footprint of a house. Basically, what you'd be doing is you'd be allowing another house on the same lot of equivalent size or even greater, depending on the primary residence. Kind of asinine, my opinion. Going to the next page, talks about making provisions for adequate water supply and sewage disposal. What is adequate? It's undefined. I think you really ought to define it, either reference some other ordinance or something. But adequate doesn't do it for me. It could be anything. Going on to where it talks about the granting of a certificate of occupancy has been crossed out, and instead it inserted building permit for the accessory dwelling unit. Shall be contingent upon the receipt of the covenant and fees. This is a place where people are going to live. You need a certificate of occupancy, not just a building permit. I mean, unless you just don't care about your fellow citizens. So I would consider looking at that with a greater degree of skepticism. Moving on to number 7, where it says, one additional off-street parking space is required above the minimum standard for a single-family house. And this adds now either on-site or off-site location and legally dedicated via lease agreement or other instrument deemed acceptable by the administrative officer. That's basically the guy in charge of the planning department. Deemed acceptable. What does that mean? There's no definition here for it. He can just sort of wing it. It could be his opinion. Moving on. So I'm going over to the table 15.1 use matrix, where in the use matrix, under row 3, which is accessory dwelling units, all of the S's in there have been crossed off. And S's mean special exception. We required a special exception before, now we don't, apparently. And instead, inserted in there across the board are A's. And A means as an accessory use, including what was previously a blank. They didn't allow accessory dwelling units in airport industrial areas. Now, apparently, with this ordinance, we would be accepting accessory dwelling units in the airport industrial area. In addition to that, there's other areas. Highway business area, park industrial area, general industrial area. I don't know, maybe it makes sense to you, doesn't make sense to me. And also, in the staff person's material, he noted that these are allowed by right. By right would be a P in that area. And there used to be Ps for, what is it? Downtown, D1 downtown and D3 downtown. And now there are A's there, which is accessory dwelling unit. So basically, you took away the by right there and you put in as an accessory dwelling unit. I don't know if that was intentional or not, but that's what you got there. And that's what I have for 2576.
Thank you. Director Sullivan, would you be able to respond to a member of the public's questions? And then that will allow him and others, unless there's someone else in opposition who would like additional questions, I probably should ask. And then that'll allow the other set of in favor opposition to come up after you, Director Sullivan, if there's additional questions. But, all right, go ahead. Looks like you're good.
Thank you very much, Matt Sullivan. I appreciate Mr. Richardson's questions and comments because they give me an opportunity to clarify some of the statements that I'd made. The first regarding the application of setbacks and other dimensional controls to accessory dwelling units. What the statute provides for is that you cannot make unique setback and other requirements for accessory dwelling units, but the customary setbacks that exist for structures within the zone continue to apply. So ADUs are still subject to all the same dimensional controls. And that's a good question because the way I'd stated it initially, I almost suggested like the dimensional controls do not apply. They certainly do. They continue to apply to ADUs when they're created. So setbacks, height restrictions, all of those things continue to be in place. There was a question raised relative to the reference to RSA 485A38. This is water and sewer adequacy. I want to be careful to not give an indirect answer here, but 485A38 lays out exactly what's required for adequacy. And we rely heavily upon either our septic reviewers in public health, our water utility at Pennachuck, who does a review of the water connection, or our sewer department, who does a review of the sewer tap, to determine whether or not the line running to the property is adequate. To be honest, I can't speak to every case, and I don't think that's what Mr. Richardson is asking me to do, but 485A38 does lay out exactly what water and sewer adequacy are. And if we want to try and provide an overview of that, we certainly can, but I didn't come prepared to do that tonight. That's the customary reference that we use throughout our code, however, when we're talking about adequate utility provision to a site, whether for ADUs or something else. So happy to provide further information if necessary, but that reference is pretty standard and it's actually provided for within the ADU statute as well. Another item that Mr. Richardson raised, which is I'm happy he did, is the striking of certificate of occupancy to replace with building permit. We absolutely still require a certificate of occupancy. That's not what our intent is with this change. This is a timing related section of the code. It says that the covenant dictating the ADU rules in the old code had to be recorded prior to when a certificate of occupancy was granted, at the very last stage of a construction project happening for an ADU. What we've now said is actually more stringent. We're requiring that the covenant be recorded prior to building permit, but that a certificate of occupancy would still be absolutely required for any accessory dwelling unit. So we're actually adding an additional requirement to protect the occupant, the property owner, et cetera. So I'm glad that that opportunity for clarification was provided. Relative to the table 15-1 and the changes there, we certainly could have changed those A's to P's. However, in our zoning code, the term A, we believe, is a more clear identifier because A includes that the use is permitted. It is defined as a permitted use, an A use, but it also makes it clear to someone reviewing the use table that that use is only permitted when accessory to another use. And in this case, it's accessory to a principal dwelling unit on a lot. And so when drafting these changes, staff felt that rather than putting P, that A would be the proper identifier because it would make it clear that it had to, in fact, be accessory. So I hope that explanation makes sense, but that's why we chose not to put P in place within the table.
I'm going to call on Alderman Clements just because the interest of the public on this particular matter. Alderman Clements.
Thank you. And further, and you can correct me if I'm wrong, but A, meaning accessory dwelling unit, by state statute, they are by right So if it says A, we're gonna know it's by right anyway because the statute says so.
Correct.
Okay.
Yes, correct.
Thank you, Alderman Clemmons.
I believe I may have missed one of Mr. Richardson's comments, but the other that I did want to just speak to quickly is the item 7, the administrative officer discretion. I'm happy to amend this language if the committee feels it necessary. The intent here was to, frankly, avoid trying to be too prescriptive in what an acceptable dedication of a parking space would look like, because it can look very different in different forms, whether that's an abutting property, a property 100 feet down the road. The mechanism may be different. We were hesitant to lay out every potential possible dedication of a parking space here. What I would welcome a conversation about during the committee meeting is whether that needs to be more clearly defined as to what those possible alternatives are for dedicated parking space. I think we're happy to add more language there. We weren't intending to provide entire latitude to the administrative officer. We were just attempting to try to limit the text needed to capture the same concept. So happy to talk about that more in the committee level if the group feels it necessary. And I think there may have been one of Mr. Richardson's comments I didn't grab, but I think I covered.
And he'll be able to have an opportunity to come back up in a moment. But I can certainly appreciate the members of the public being concerned with this combined with the next one.
Sure.
Where Airbnb and such could take advantage of maximizing space if they were to buy up property. So I understand the fear and concern in the community.
Sure.
Thank you. Again, I'll call for testimony in favor and testimony in opposition.
Dan Richardson, 70 Berkeley Street, Nashua, New Hampshire. I think what he missed was the rationale in accessory dwelling units in highway business area, park industrial area, airport industrial area, and general industrial area.
Thank you.
Thank you.
Director Sullivan.
Yes, thank you for that. That's a great question. So within our AI district, our PI district, our GI district, our industrial districts, there are single-family homes. Those districts are not exclusively occupied by industrial tenants. We have to provide those single-family homes with the ability to add an accessory dwelling unit. This would not mean that a factory could add an accessory dwelling unit. In fact, that wouldn't be allowed. But if an existing single-family home existed and wanted to add an ADU, they would have the right to do that. And so that's why we've codified it that way. I hope that addresses the question. I think the intent was not to provide for proliferation of accessory dwelling units in those industrial zones, but to instead allow existing non-conforming residential uses to take advantage of the statute in the same way that they're allowed. That was the intent there.
Great, thank you.
Yes.
And there'll be another opportunity to comment on all of these at the next, after a public hearing, to open up the committee at public comment as well. So with that, anyone else in opposition? Seeing none, I will declare O-25-076 closed at 7:39 p.m. and open the public hearing for O-25-077 at 7:39 p.m., amending the land use code regarding unrelated households. Testimony in favor? And testimony in opposition?
Daniel Richardson, 70 Berkeley Street, Nashua, New Hampshire. Back a number of years, when Alderman Presley was on the Board of Aldermen, the issue of density of unrelated individuals living in single homes, or homes, let's call them houses, they're not homes. And that came up, and it was found through a little research at the time that there were people living in houses like cockroaches, packed in there. 10 to 20 individuals in a house. And it was obviously against code. However, there was no way of proving that these individuals were not related. So It's my understanding that came to naught. So Nashua still has that, presently has a situation. Not much you can do about it, I understand. However, this ordinance, as it is appearing to present itself, would completely eliminate any such restriction at all, even if it's an unenforceable ordinance. What's crossed off is no household other than a family shall have a number of members exceeding figure provided in Table 16.1 below entitled Occupancy Restrictions. And that's that. That, in addition to the prior ordinance that we looked at, 076, are very damning to the city of Nashua. We're not talking about my neighborhood. We're talking about the quality of life in the city of Nashua. We're talking about Ward 6, Ward 8, Ward 9, Ward 3. We're talking about a lot of different places in Nashua that can be affected by this. One further change here is that Table 16-1 is crossed off. This is occupancy restrictions. And this table provides for a limit on the type of dwelling. It has a number of persons per square feet that can be there. And previously, there was a limitation on 300 square feet, number of persons per 300 square feet. So the first line is single-family dwelling, one person. 300 square feet. Do you understand what 300 square feet is? If you use a simple square root to come up with a square area, that's 17 by 17, that's the size of a room, a single room. So we allowed one person per room. Now we're completely eliminating that table. We are saying that we don't care how many people we pack into any of our residences. We don't have a fire code restriction. Nope, they don't go around inspecting for fire code on these places because we won't have an ordinance on that. So it goes on, it talks about duplex, townhouses, apartments, bed and breakfast, rooming, dormitory, fraternity, sorority, nursing home, elderly housing. You know, getting rid of the limitation on elderly housing too. Let's pack in grandmas and grandpas. Talk about devastating to the quality of life in Nashua. You really ought to pay attention to this. Thank you.
I'll call for anyone else in opposition, and then Director Sullivan can respond to those members, the public's comments. Anyone else in opposition? Director Sullivan.
Thank you, Mr. Chair. I don't know that there are direct questions to be addressed relative to the prior comments.
Concerns, sorry.
Yeah, no, absolutely. And I think Mr. Richardson has raised some very valid concerns that have been debated in this chamber several meetings in the past. I think given an opportunity to set realistic and clear over-occupancy thresholds, I think members of the board would choose to do that for fire safety and life safety reasons. However, we functionally lost that ability, and it's very, well, it may seem that there's a clear line as to what over-occupancy looks like. I'd suggest that that's really not the case. We have couples living with a young child in apartments that are 750 square feet that wouldn't meet this requirement. We have young adults that are struggling to make student loan payments living in small apartments and small homes that are over-occupying based on the table that you see before you. So I'm not suggesting that there shouldn't be some life safety standards. I'm simply saying that it's very difficult to define what the appropriate occupancy is. As I mentioned before, I expect that this change may spark a conversation about whether or not we should have, again, we can't regulate family versus non-family, but whether we should have general occupancy standards But again, I would urge caution because we have many situations throughout the city where people are living far beyond the limitations that are laid out in this table. And in some cases, it is just fine, and there isn't over-occupancy. So where do you draw the line? And you certainly can't draw it based on whether people are related by blood, marriage, or the other. We know that now through the state statute that has passed. But I really can't offer additional comments. I don't disagree with Mr. Richardson, and I'm not debating him at all, because I think there is some line where safety becomes an issue and overcrowding does happen. My challenge is it's very difficult to actually define what that line is, and you can't do it based on familial relationship. So we need to have a broader conversation if that's something that the board would like to do. So I guess that's a general response to Mr. Richardson's concerns.
Yes, of course.
Thank you. So, one, this is laws coming down from the governor and the state legislature. So that's part of this. But the one thing I thought I read in there is about fire code. That still holds up, right?
There are still fire code requirements, and I expected I might get that question. I don't have that number right in front of me right now, but there are still fire codes that apply, but they apply based on the occupancy classification, right? So they're going to apply differently in a single-family home versus in a multifamily context. There are different code requirements for that, and they focus on fire suppression and adequate ingress egress to a unit. So I can try and grab some of those numbers for you, but those codes do still exist. Those have not been undermined. It's simply that a land use code can't further regulate based on familial relationship. Again, you have the right to regulate occupancy. It's just a bit of a dangerous game as to what the right way to do that is, and what the right numbers are that mean over versus under occupancy. It's a very challenging thing to do, I guess I would say.
Alderman Clemmons.
I'll wait till the committee.
Okay. Thank you, Director Sullivan. I appreciate the comments. So then again, I'll open up for testimony in favor and testimony in opposition. Seeing none, I'll declare the hearing of 025-077 closed at 7:47 p.m. And I'll declare the regular meeting open at 7:48 p.m. And we don't have to. Do we have to redo the roll? Anybody? No? Okay. So public comment for anything to be acted upon tonight. Please come up and state your name and address. Seeing none, communications?
Do you want to take that one?
Yes. Without objection, I'll suspend the rules to allow for communication that was received after the agenda was prepared. And that was from Alderman Lopez regarding the ADU legislation.
We have communication from Connor Muse, Deputy Planning Manager, regarding referral from the Board of Aldermen on Ordinance O-25-073, amending the land use code regarding approved subdivision exemption. We have one from Connor Muse, Deputy Planning Manager, regarding referral from Board of Aldermen on Ordinance O-25-074, amending the land use code regarding family daycare facilities. We have a letter from Connor Muse, Deputy Planning Manager, regarding referral from the Board of Aldermen on Ordinance O-25-075, amending the land use code regarding parking requirements for residential uses. We have one from Connor Muse, Deputy Planning Manager, regarding referral from the Board of Aldermen on Ordinance is O-25-076, amending the land use code by amending the accessory dwelling unit ordinance and definition of dwelling unit accessory. And we have one from Connor Muse, Deputy Planning Manager, regarding referral from the Board of Aldermen on ordinances O-25-077, amending the land use code regarding unrelated households.
There being no objection, I'll accept the communications and place them on file. Petitions?
None.
Unfinished business?
None.
New business resolutions?
None.
New business ordinances?
We have O-25-073, amending the land use code regarding approved subdivision exemption.
Is there a motion for final passage, recommendation for final passage?
Yeah, I can make the motion to recommend final passage.
Thank you. Discussion on the motion? Okay, seeing no discussion, all those in favor say aye. Aye. All those opposed? The ayes have it.
We have O-25-04, 074, amending the land use code regarding family daycare facilities. I'd like to make a motion to recommend final passage.
That motion's in order. Discussion on the motion? Alderman Jettie.
Yeah, I think I have something, but I'm having trouble catching up. And, so, I guess the change is in paragraph B, where we say that.
Alderman Jettie, hold on one second. Director Sullivan, could you join us? I'm sure most of these questions will probably be more apt for you or Manager Durfee to answer. My apologies. Continue, Alderman Jettie.
It's okay.
I believe a comment was made relative to Alderman Jettie using the microphone just to make sure.
Okay, right in there, Alderman Jettie, right into the microphone.
Thank you. Thank you for pointing that out. So, as I'm reading the paragraph B, childcare facilities located within a dwelling unit are permitted by right as an accessory unit to the primary residential use, provided all requirements for such programs adopted by rule by the Department of Health and Human Services are met. And then subparagraphs 1, 2, 3, 4, 5, 6 are eliminated. So my question is, does this now allow someone to to care for children in their home? In any number of children? There are no restrictions on the number of kids that can be in there, or does the Health and Human Services rule take care of that?
Director Sullivan.
Yes, thank you for the question. And I should have mentioned that you may have heard me say at the beginning, I was a little hesitant to go into the detail of HEC 4002. HEC 4002 is an 85-page document of rules and regulations produced by the Department of Health and Human Services. And included within that is a variety of different child care typologies, licensure requirements for different sizes of facilities, licensure requirements for child care providers. I'm going to give a relatively undefined answer, Alderman Jay, to say that I believe that would limit size to a certain number of children based on the size of the care facility, that a small household would not be able to take on 50 or 75 children without adequate space because there are spacing requirements within that administrative rule. But I can't speak to the detail of whether that would be 5 individuals or 5 children, 10 children. But I do know that those space requirements and area requirements do exist within that administrative code. So we're very much relying on the state to continue to apply the same thresholds for child cares that they have for many, many years. But if there's specifics about what those numbers are, I'd have to return to the committee to answer those questions. I apologize for not knowing the answer tonight.
Alderman Jettie.
Okay, well, so maybe I could ask some more questions, and if you don't know the answer, you could say so. But, what I'm concerned about, without knowing a whole lot about this, but what I'm concerned about, is are we going to be allowing, unlicensed people to care for children in their homes?
No,
Director Sullivan.
yes,
that's
no,
a no.
I'm happy you asked that question, Alderman Jettie. The answer is no. They're still subject to the licensure requirements of DHHS. There's just an alternative process for these facilities. Yep, there's still the stringency of the licensure has not changed, as I understand it. It's simply that for smaller in-home facilities, there's an alternative process that they get licensed through the state of New Hampshire. But these are still, as I understand it, qualified individuals providing child care, and there's still a review process by the state for each of these for each of these physical facilities. It's just that there's a slightly modified process to do that.
Okay, and so I guess the corollary of that is, so is it prohibited for, someone, a woman who has small children and wants to go to work, is there anything prohibiting her from leaving her children with a relative or a friend? What exactly, what's the difference and how is that defined?
Sure. I'm gonna take a stab here, and I think there's a certain level at which I can't speak to, and I'll get to that in a second. Certainly, a component of this is whether there's a financial transaction happening. So if someone is operating a commercial child care facility and they're getting paid to provide child care, that's when, certainly in the context of our zoning ordinance and also I believe in the context of DHHS's administrative code, there becomes a requirement for licensure when you're providing child care as a commercial service. So if I were to leave my children with you, Alderman Jetty, and you're doing me a favor to watch them, that wouldn't require a child care license through the state. What I don't know the answer to is whether or not there are any exemptions in the state administrative code for one child or two children, or if I have a babysitter overseeing my two children off-site. I can't speak to what the administrative code calls for there, Alderman Jetty. So there's certainly you know it if you see it, and likely a definition within the administrative rule, but I do not know what that number is, and I'd have to get back to you, unfortunately.
Okay. But by amending this ordinance, what we're dealing with is, not the supervision of childcare, but we're dealing with whether or not we allow childcare in a use from a zoning use
Yes,
point of view.
correct. From an accessory residential perspective, yeah, that's absolutely right. Yes, yes.
So in summary, if someone is licensed by DHHS and meets their the state level requirements, the state is saying there's no additional steps you need to take locally for your facility to operate. We've determined it's appropriate to continue without that additional burden.
That is correct. Subject to any permitting that's needed to build out inside or make the facility ready, they are by right. I would want to confirm this, but I believe it's possible we'd still require what we refer to as a land use permit, which is basically a signal to the city that you're implementing a new use within a given area. But again, that would be by right. There wouldn't be a public hearing process or anything of that nature, but we would document that childcare use is being created within a given area. And we'd also be ensuring that they have an adequate license through the state of New Hampshire in the context of these requirements here.
Great. Alderman Tebow.
Thank you.
Thank you.
And I think too, based on what I read in that 85-page document, and I didn't read the whole thing, but some of the stuff I looked at is there's still rules around it.
Yeah.
You got to have, I believe, a fence. Kids have to be in the backyard. There's got to be certain place in the house that's separate from that's so many footage. So all those rules still exist. We just no longer are the gatekeeper of that. It's the state. I mean, obviously we would be involved, but the state rules now apply. And if we didn't pass this, we can't really apply our rules to it because we got to go by the state rules. That's basically what all this legislation is. All the pieces we have tonight are the state has made changes, and our rules do not exist anymore for the things that they have altered or changed or required. So we might as well put in line with what the rest of the state has. Is that correct?
Yes.
Okay, thank you.
And that's a lot of the feedback I've gotten from my peers, like, why are you putting this forward? Like, what's going on here?
Yeah.
And the conversation has been, it's dictated by the state. It's almost like we have no choice except for some minor little changes here and there. Alderman Govea.
Thank you. I just pulled up the kind of the regulation document from the state, and based on my 2.5, 3 minutes of just searching through it, it does seem that there's a minimum of 35 feet of net floor area per child inside the rooms used by children, and then there's a bunch of other kind of calculations that go into that as well. But it does seem that 35 feet of net floor area per children was the basis block of size.
And, Alderman Jettie, go ahead.
Through you to Alderman Gouveia, so your quick reading, does it talk about, the exception that I was kind of looking for, where, a parent who knows somebody, whether it's a relative or a non-relative, a friend or whatever, does the parent have the right to entrust their child to that other person without having to go through the state?
Alderman Gouveia.
I swear I thought I read something that said it was like 2 or more, but I'm not positive. It was in here, I found it, and I have not been able to find it since. But if I do, I will let you know.
I will say that the DHH requirements for a lot of the services that they oversee, just like this one, are rigorous. The issue is enforcement. But it may be a benefit that the city of Nashua doesn't have to enforce this, and the state has taken it out of our hands, as we've seen recently with the disabled homes that have come under scrutiny. This is a move that they find that they need to oversee, and that's where we probably should leave it if they think that's best, and hopefully they can enforce their law. Alderman Clemens.
I think this may be a situation where if you hire a babysitter to babysit your 3 kids, maybe they should have a license. They should probably also report that income to the IRS, and whether or not both of those things are going to happen, I doubt.
Oh, man.
But it is what it is.
You spark, Mike. If people could report their income, I would just be happy, because then it would make me feel better about all the taxes I pay. Sorry for that going off. All right, so any further conversation? All right. Seeing none, all those in favor say aye.
Aye.
Aye. All those opposed? And the ayes have it.
We have O-25-075, amending the land use code regarding on-site parking requirements for residential uses. I'd like to recommend for final passage.
Any conversation? Alderman Clemens.
Thank you. So, yeah, I had a question on this one, on the maximum parking spaces that we put in for manufactured home, and then also multifamily dwellings of 3 or more. Looks like that one stayed the same, but the manufactured home, it looks like it said 22. Was that correct, or?
Director Sullivan, I'm going to continue to call on you because I really don't want to upset
Yeah.
Sam's new baby.
Yeah, and I think we're actually having audio issues, so Sam
good.
said he can't.
Good for him.
He has a 90-second delay right now. Yes, he'd like to contribute, but hasn't. When you say correct, that's a matter of perspective. It was clearly an error that existed in the code.
Yeah.
We don't know how it got there. It wasn't supposed to be a maximum of 22
Right.
spaces.
That's what I thought.
What we found is that it was supposed to be 2. So we're simply, frankly, we're just maintaining this at what it was before.
Okay.
One question I was actually a little nervous about getting, so here I'm offering, is the 1.9 per unit on multifamily. We did a little digging on that about where that number came from. I think there was some study that created that number in the past. We're going to change that obviously in the new code, but we're not proposing to modify it whatsoever. But there was a data-based approach to develop that 1.9 number on the multifamily. But 22, that is not, it's not right. So we're changing it and
Okay.
correcting it.
All right, thank you.
Do we need to do that now or wait for the state to, or is this just a copy paste? What's going?
You can take a leadership role and
Yeah.
do it now.
Yeah. Does anyone have an offer an amendment?
No, it's
It's
already.
already
Oh, it's already in
Yeah,
there.
it's already in there.
Oh, okay.
Yeah.
Sorry,
Yeah.
my mistake. Alderman Gouveia.
Thank you. I guess my question to go off of that was, why are there maximums? If I'm developing or building, why put a cap on extra parking?
Yes, it's a great question, Mr. Chair, if I can just address that.
Yeah.
So certainly, within our downtown core area particularly, we have tried to make most efficient the use of land. And so we have tried in some cases, particularly urban environments, to limit the creation of parking, to not create large vacant parking fields where they may not be needed, and to try and align parking strategically with dwelling unit demand. And so it's not uncommon in urban community settings to see maximums established to prevent the creation of parking that won't be a productive use of land because it won't be used by the surrounding multifamily dwellings. And so that number was studied to be sort of a demand number. We actually see the demand number range anywhere from 1.1 to 1.3 to 1.4 spaces. It's a number that Manager Durfee, Director Cummings, and others and I go back and forth on all the time. But the goal is essentially to eliminate the creation of large parking areas that won't be used.
Okay.
That's why.
Thank you.
Anyone else? Seeing none, all those in favor say aye.
Aye.
Aye. All those opposed? The ayes have it.
We have O-25-076, amending the land use code by amending the accessory dwelling unit ordinance and definition of dwelling unit accessory. I'd like to make a motion for final passage.
That motion's in order, and I'll say that we do have one meeting left before the end of the year, so if there is amendments that need to be made, we can do that sufficiently if we can also commit on being present in a quorum before the holidays. But otherwise, if we do leave it tabled and we can't get back here in December, we'll continue to the next board, because I know this one and the next one are of some contention, and no need to rush.
Are we on 70? Which one are we on? I'm sorry.
7-6.
76, yeah. So I think the most specific thing here, and correct me if I'm wrong, is the square footage of what the maximum can be, et cetera.
Yes, that's correct. Mr. Chair, there are a few other things that we've changed here based on Nashua's processes, but I'd say the most substantial deviation is the creation of that 980 square foot maximum. And I know Manager Durfee can't speak verbally, but if you'd like more explanation on that, we'd certainly be happy to provide it in written format. As I mentioned before, it was derived from study of ZBA actions.
And to represent to the committee, I did meet with Manager Durfee before this legislation was introduced, and that is what he represented to me through the consultants that the city uses. This was identified as a ideal square footage based on the overall bird's eye view of the need for the city and our current requirements. I may have misrepresented that, but you can correct me if I'm wrong.
I think that's correct.
All right, Alderman Clemens.
So am I understanding this correctly, that the minimum is 750 or is the minimum 980?
The maximum is 980 square feet, Alderman Clemens.
What is the minimum?
There is no minimum. The minimum would be controlled functionally by how small you can build an accessory dwelling unit. Fit the kitchen, cooking, sleeping, and bathroom facilities in one area. So technically, you could create a very small accessory dwelling unit.
Alderman Clemens.
Yeah, so I'm thinking like if you were to put a tiny home in a backyard or something like that, 350 square feet maybe.
So to address, I get very antsy when we talk about tiny homes.
It wouldn't be a tiny home. It would be an ADU.
Yeah, no, just, yeah. A small
I know what you
home-
mean, though. Yes, yeah.
A very small home on a permanent foundation connected to sewer and water could absolutely exist at about 400 square feet, absolutely. As long as it's on a permanent foundation and has the facilities, absolutely. There's sort of this battle going on right now in the construction world as to how small you can make a unit, but it turns out to be around 350 to 400 square feet in size.
Alderman Clemens.
So my other question is, why would we, so the 980 is only for a detached, and it's 1,200 if it's within the unit, is that correct?
So the 980 applies both for a detached unit and also for an attached unit where structural expansion is happening. So if you're adding on an addition to build an ADU, you're capped at 980 square feet. Where you get an exemption is if you have an existing footprint and you're building fully within that existing footprint, you get up to 1,200 square feet. The idea there is that if it's an existing structure, sort of to some of the public testimony, it's an established structure that your neighbors and the neighborhood is aware of. And so if you're keeping within that, the impact is lessened. That's sort of the theory there. I think hopefully that makes sense.
Yep, follow up.
Now, on all of these, if someone wanted to go to the zoning board and get an exception because maybe instead of 980 square feet, they want to do 1,000 square feet, they could still apply for that exception and go through that process to try to do something like that. Or vice versa, if it was within the existing unit and for some reason it was 1,300 square feet, they could go and get that exception.
Director Sullivan.
They could absolutely seek a variance through the
Yep.
zoning board of adjustment. They'd have full rights to do that, absolutely. And there may be some hardship that would justify that. So yes, that could be an option.
Okay, I just want to make sure, if I
Yep,
could
of
continue,
course,
I just want to make sure that that opportunity exists because, having, I like having limits, but, thinking for, older units or older houses, where there might be the opportunity to do something within an existing structure, you might run into a situation where if you're splitting a duplex, for example, right, and you have a single family house and you're making it a duplex with one on one floor, one on the other, but they're both 1,400 square feet. But it's a very easy divide, right?
Yeah.
Then that's something that you'd want that person to be able to go to the zoning board and ask for a variance to be able to do something like that, right? So that's kind of my thought process behind the ability for somebody to be able to do that.
And before I move on to Alderman Govea, it's just one ADU per residence lot?
Dwelling unit.
Dwelling unit.
Yes.
So if someone had one dwelling unit on 10 acres, they could only do one ADU?
That is correct.
Great. I'll say more for a little bit after Alderman Govea. Alderman Govea.
No, mine was just what Alderman Clemens brought up about turning a house into a duplex in that kind of situation, because I could see this kind of opening the door for that a little bit more, which I don't think in some areas of town is necessarily the worst thing in the world, but.
I'm glad that question is being asked because duplexes are allowed in a large portion of the city. So ignore the ADU law for a second. There are several properties in some of our most sensitive neighborhoods that could be converted into duplexes today. I mean, that could happen. Some of the city's most historic structures could theoretically be divided into equal footprints and converted into duplex and even condoized. I'm not saying that would happen, but it could be done. So I mean, I just want to, ADU legislation may be viewed as being very problematic, but a lot of the permissions or a lot of the fears around ADUs are actually things that could already be done today in the existing zoning code. Not every neighborhood, certainly, but some of these permissions already exist.
Now, can you put an ADU on the property and then 5 years later split up the land with one? Now you have one on.
That's a great question. If you had a lot and you had a house on it and you added an ADU, you were allowed to do so by right today, but you had enough land to subdivide, build another house, and build an ADU with that, you would technically have that right today. Yes. There have been prior iterations of this bill at the state level that had 2 ADUs by right for every dwelling unit. To be very frank, city staff, well, I'll speak for myself only. We expressed concern about those pieces of legislation because we felt that for many neighborhoods that it would have been too impactful to the character of those neighborhoods. So I think there is a line where this could go too far, but I believe that one detached ADU can be done in concert with the existing fabric in most neighborhoods in the city.
But keeping in mind, keeping in mind the members of the public too, the square footage, my first house in Dickerman Street here was 950 square feet. That is a house.
Yep.
And we're dividing, where the state is saying that that's now an ADU, depending if it's on an existing dwelling unit or detached, et cetera. So I could see how the risk of one side, people can build these, have generational living, have their in-laws move in, stabilize their immediate family, nuclear family, then just like we've seen in other communities, which I've been attuned to, is the people coming in like VRBOing it, Airbnb, not that platform specifically, but a company that buys it up, makes these ADUs. Next thing you know, they're right in the main house, the ADU, and you've lost your neighborhood. It happens, but again, out of our hands. Alderman Tebow.
Thank you. Yeah, don't say classic or historic. I'm on the Historic District Commission. I don't want you touching any of those houses. And I know somebody in your department would probably, might be after you tomorrow morning. Don't split up those places. So you may have answered this when we talked about the parking, but so you put one of those little tiny houses in the back on a foundation and hooked up to water, and they never had a parking space available for someone else. Do they have to build one there? Do they have to make one? Is it required? Is it not? Like, how do they, I guess, rectify that, or?
So let's take a few different scenarios. One, you have an existing home. It has one parking space on site, and I want to build an ADU. And I can't fit a second parking space. Well, that's a problem, because for each ADU, you're required to have one parking space. And if you only have one on site, that's your single-family parking space. You need to find another one. You can reach an agreement with an abutter to have a perpetuity restriction on a parking space there, a dedicated parking space. You can reach an agreement with an abutter down the road, or maybe not direct abutter, but someone down the road for a dedicated parking space. You can provide parking in a variety of different forms in the ordinance as it's drafted, but you got to find that parking space. Now, let's say I have a single-family home, but I have 2 parking spaces on site right now. I can add an ADU without any issue. I have 2 parking spaces available to me. State law says the city can't require me to have more than 1 per dwelling unit, whether it's a single-family or an ADU. I've met the requirements. Now, am I going to run into practical concerns because, my family has 3 cars and the ADU is going to have 1 or 2 more cars? Yes. I think that's some of the challenge with the 1 parking space per dwelling unit legislation that the state passed, quite honestly. I think it's a little bit context ignorant, but technically that would be allowed today.
Yes.
Thank you. So is that something that you guys need to look at before they can put the ADU? Is that part of all the stuff you have to fill out?
Yep.
Because, they could just park on the street, right? I know it's against the rule, right, overnight parking, but I see it throughout the city all the time, even on my street, right? So, somebody could just park on the street. They could say, yeah, we don't have it, but we're fine, whatever. You guys have to approve that first for them to get it. So that could prevent someone from putting an ADU on if they don't have the parking space.
Absolutely.
Okay, thank you.
Any further conversation? Alderman Jettie.
So Alderman Tebow brings up a good point. He mentions the historic district. He said, I don't want you touching the historic district. But if we pass this ordinance, you can, we won't be able to eliminate ADUs from the historic district.
Director Sullivan.
Well, you won't be able to limit ADUs within the historic district from a use perspective. The historic district will maintain fully its jurisdiction when it comes to applying the historic district review process to building permits necessary for ADUs required within the historic district. Now, there are a couple different scenarios here. If an ADU is being created in an existing structure and the building permits that are necessary are just to fit up that structure, the HDC's review is going to be very limited, and I would urge them not to deny any of those permits. Now, if in the historic district, I am building a brand new, very modern structure for my nice detached accessory dwelling unit, I believe the historic district has some discretion to review that proposed building and determine whether it's compliant with the historic district rules and guidelines. Provided that that HDC review is in no way different from any other permit review that it does, I believe they can equitably apply those rules and regulations. So I hope I'm being clear without being unclear. HDC could deny building permits related to accessory dwelling units. They simply could not do so on the basis of use alone. They would have to do it on the basis that it doesn't comply with the historic district standards.
Okay,
Follow up?
I thought, I'm not finding it right now, but I thought they were in the proposed ordinance, there were specific things like no exterior design of the accessory dwelling unit shall be compatible with the single-family dwelling through architectural use of building form, scale, and construction materials. That's struck out.
Director Sullivan.
Correct, but what the ordinance does, so that's correct. Those very specific focus requirements that exist in the ordinance before that were applied uniquely to accessory dwelling units, those have been removed because we can't treat accessory dwelling units uniquely any longer. But what can be done, Alderman Jettie, in my opinion, is that the historic district rules that would apply to a new single-family home being built can absolutely apply to an accessory dwelling unit that's being constructed. You just can't unduly restrict or regulate ADUs any more than a single-family home or other. I hope, does that make sense?
I found what I was thinking about.
Okay.
It's in paragraph B, subparagraph 11. This is being added.
Yes.
It says, where the standards of this section conflict with those found elsewhere in Chapter 190, Land Use, the standards of this section apply. So I'm reading that as saying that this overrules anything else that might be in Chapter 190. I'm not sure about that, but I'm just raising the question.
What I believe the function is of number 11 is to identify any areas where there's direct conflict between provisions of the proposed ADU language and Section 190. But conflict does not exist between the proposed language and the historic district regulations. They're completely different sets of regulations that I think would both apply to an accessory dwelling unit. I think what we're really talking about is something more direct, such as if the parking table said that 0.8 parking spaces were required for an accessory dwelling unit, but this ordinance says 1 space is required, this ordinance would supersede the parking table. But I view the historic district regulations and this accessory dwelling unit section as entirely different and not conflicting in the way that Section 11 is meant.
If I can add, maybe this is a question that if we continue to move forward and it doesn't get tabled, to bring this question through you and to
Sure.
Corporation Counsel.
Sure.
That way, if it does get to the full board either way, that there's a clear answer, so all the members, not just here, but the full board has a clarity on it. Does that make sense?
Yeah, and Alderman Jay's question is a good one. So it requires a thorough answer. I'm answering it, but I think we should look at it further if there's any
And if
question.
it turns out the conversation is, I got Alderman Tebow after Alderman Clemens. But if it turns out that it's, the conversation continues and there's not many more clarifying, if that's just the 1 or 2, then maybe we can just clarify at the full board as well. So you have a straight answer from legal? Alderman Jettie?
Are you asking?
Yes, would that be
question to me?
sufficient to get, making sure you have the right answer?
Yeah, so how do you feel? I mean, would you rather have time, would you rather we table this particular ordinance? And so you have time to come back to the committee?
Yeah.
Or are we, I can tell by the expression on your face, the answer is no. But-
Mr. Chair, if I may.
Yes.
I'm always concerned about waiting until the last meeting of the session. So if I'm being transparent, that is my concern. I'm also thinking that the answer to your question relative to Section 11, Alderman Jettie, is a fairly simple one that I can get you prior to a full board meeting. However, if there are other things that you think you need clarification on that I can't answer tonight, I'll accept that I have to gamble on a December PEDC meeting. But my goal would be to take all of the questions that you have tonight, go to work before Friday of this week, developing a communication for a full board that addresses the committee's questions, and take my chances next week with you. That would be my goal. And I'd be happy to be there next week to speak during public comment or during the consideration of the legislation as well to address any of those items.
Okay, if I could respond.
Yes.
You know, I agree with you wholeheartedly about doing things at the last minute, but
Understood?
aren't you the one that's bringing this to us at the last minute? You know, I mean,
Yep.
is there, you know, if we don't pass this year, I mean, is the legislature requiring that we do this before the end of the year?
Can I just jump in? I don't want to have that energy go straight to Director Sullivan, but it was the end of the term of the State House coming in the summer, followed by having enough weeks for the public hearing notices, and making sure that we wrote and updated the ordinances in between these.
Yeah.
I mean, it wasn't like a jam through, it was just the time from passage to here.
Alderman Jettie's correct. We could have brought this legislation in September. So it's a self-inflicted procedural dilemma.
I tried to get you out of these.
You did.
times.
You did, and I'm going to accept.
I would
I'm going to
never do that
accept.
for Director Cummings.
What I'm going to do is I'm going to blame Manager Durfee for having a child. No, I'm just kidding. He knows I'm
We're
kidding.
pulling the child. Okay.
No, no. In all seriousness, I do accept blame for that, and I think to answer directly, in the event that this needs to continue on to next year's session, that's fine. If we think we need more time, I guess what I would ask is if we, at the end of the discussion this evening, I would like to try and get you a communication in advance of next week. If you don't feel comfortable, I accept that we'll go to a December PEDC and have a discussion, and I'm absolutely okay with that. But so far, what I've heard this evening, they do not seem like significant issues that need to be addressed. And frankly, my tendency is to try to get you a communication like tomorrow or Thursday so that you have an answer immediately, so that you have enough time to prepare for a meeting next week. But again, I agree, we would absolutely accept if we have to go into the next session. It is a matter of timing, and we accept that. That's not a problem at all.
Alderman Jettie.
So, do I
Yes.
still have the floor?
You do have the floor, yes.
Yeah. So the other issue is the restriction on the number of people that can occupy, whether it's the ADU or any of these things.
Yeah.
I mean, we had this discussion some time ago when we were looking, in anticipation of the new code changes.
Yep.
We had a discussion with Mr. Durfee, about, I guess we didn't know about what the legislature was doing at the time, because we had a big discussion about family members and non-family members.
Mr. Chairman,
Oh,
is
that's the next
this is
piece.
that's the
Yeah.
next ordinance.
That's 025-077,
Okay.
Alderman Jettie. Thank you, Alderman Clemmons.
Thank you.
Yeah.
So I think if there's any further conversation, oh my gosh, you're right. I forgot Alderman Clemmons
No,
and Alderman Tebow.
I'm good.
Alderman Tebow, sorry. Alderman Jettie, distract me.
So, it was your fault for bringing up the Historic District Commission. we probably wouldn't have ever even talked about that. I look at it this way. If you want to put an ADU in the back of a historic district house,
Yep.
and it's shaped like a UFO, it's not going to fly with the Historic District Commission. I think we have that kind of leniency to deny that. If
No
you're going
pun
to put
intended.
one in the back that has a similar feel
Yeah.
to it, I think it works, right? Because you don't want to go against the ADU, but you want to still have that feeling that you're in the historic district. It's like saying, we all have the right to put windows on our house, but in the historic district, those windows need to fall in line with the period, right? So I look at it that way. And so I think historic district is separate from the ADU, because it goes against things that are in the law now that reside in the rest of the town, right? So that's how I look at that. Otherwise, we don't even need the Historic District Commission anymore if they can't rule on things like that. But you're right, the ADU would still be part of that. You still could put that in a historic house. It just has to have the feel of it. That's, from my experience with the Historic District Commission, that's how I feel it's going to run. Now, again, I would certainly check with somebody and make sure that it's aligned. But these changes that we have here are, it's not like we're coming up with them and we're like, hey, we got to do all this stuff before the end of the year. Our rules now aren't in effect anymore. The state rules are in effect.
That's right.
So it doesn't matter if these are on our books now or not. Except for a couple of tweaks, we can't enforce the stuff that's in our ordinances for these things because the state law takes effect. So believe me, I don't like some of these things. I don't like the next one, certainly, and I don't like this one to a certain extent. But that's going to be state law no matter what. We can't change that. None of us here are state legislators, so we're not going to be able to change that. So that's how I look at these. I don't look at it as a big a problem as if we were creating the legislation ourselves, and then we could say, oh, we don't like this, we don't like change this, change that. That's different because it would be in our control. I don't think a lot of this is in our control, so.
Alderman Clemmons, also, Director Sullivan, is there a way to find out who did and didn't vote from the national delegation, both state reps and Democrats? I'm sorry, both state reps and senators.
I'm sure there is a way.
Just curious if this is something that they advocated for and supported and represented on behalf of the city for changes.
Let me discuss that with the mayor's office. I'm not sure who voted, but we can
No,
certainly.
but I would just be curious if
Yes, no, we can find out.
if the
And-
full board here would not make some of these changes, and then
Yes.
our state delegation supported such, it doesn't seem like there's a good cross communication between the two bodies of local and state government representation. Sorry. Alderman Clemmons.
No, I'm good.
Great. Any further discussion?
Mr. Chair,
Director
may I
Sullivan.
just ask
Yeah.
the items, so I owe some response on the function of item number 11 and how it relates to other sections of the code. I'd like to specifically address the HDC standard application and whether these ADUs would be subject to the HDC and all their power and authority. I'm going to give you a little more depth on 980 square feet. I think you've addressed it, Mr. Chair, but I'll get something in writing, and I can certainly get something about what members of the national delegation weighed in. I'm not aware of any other specific items that you'd like information on. I was just trying to remember if Alderman Jettie had any other questions that I needed to follow up on.
And if anything comes up afterwards, feel free to direct them through me to Director Sullivan.
I don't think so. I think,
Okay.
you know, with Alderman Tebow, if he's reminding me that, you know, if what he's saying is true, that this is being dictated to us by the state legislature, and I thought there were tweaks that you kind of hinted that we could make, but if we can't, we can't, and I accept that. I don't want to, you know, I don't want you to be chasing down stuff just out of curiosity. I think if we're stuck with what has been proposed, then we're stuck with it. But if we're not, then it's worth pursuing. But if we don't have any choice in the matter, I don't want to make extra work for you.
If I can just
Yes.
briefly respond. So thank you. And Alderman Jay, there are a few items in here that are of our own making. The 980 square feet certainly exceeds the 950 that's contemplated in the statute. We've gone 30 square feet above what the statute contemplates as a maximum ADU size. So that's one example. The 1,200 square feet that we've included for contained ADUs with existing structures is something of our own making as well, that flexibility to provide for bigger ADUs within existing structures. That's something that our team came up with based on experience in our office reviewing applications. The timing of the covenant restriction being tied to the building permit, that is something that we devised to try and get that covenant in place earlier so that enforcement could happen easier if the conditions weren't being met. Relative to parking being allowed off-site, that's something that our team came up with. Parking must be provided, or the municipality has the right to require parking. We wanted to provide more flexibility for off-site parking, and certainly that's something that we came up with. So Section 7 could be amended. The final section that I'm aware of that is a creation of ours is item 10, though I think there might be backing for this in the statute, and that is to say explicitly the ADUs are associated with single-family dwelling units and not with multifamily dwellings. We wrote that language more for clarification purposes. I think the statute's implicit about that, but that's something that I believe our team came up with to make it very clear what we intended by ADUs. So there's some creative thought at work here based on our staff's knowledge of the process, but the other pieces of this, the bigger pieces where it's detached, that's all coming from state statute. So hopefully that summarizes it.
All right, and we'll look forward to all those questions. If there's anything else, feel free to email myself and Director Sullivan. I will add one benefit of this is for folks who do own property and are have the ability to add on an ADU and then make extra income through renting it out to support retirement or whatever it might be, just like we talked about earlier, side gigs and 1099s and people not wanting to pay their taxes. This way, it's much more likely someone will have legitimate revenue that they can make leveraging their property value at the same time. But again, the side fear for me would be who's scooping up properties and building the ADUs, and are they short-term rentals, long-term rentals? Are they actually impactful to the housing crisis? Those things have really taken away from us with this state legislation. But we're dealing state. Alderman Jettie.
Before we do, so now that you kind of reviewed things, it kind of reminded me of, paragraph B's, subparagraph 1's, subparagraph A, where you talk about if an accessory dwelling unit is proposed to be developed within an existing structure, and no expansion of the footprint of that existing structure is proposed, the accessory dwelling unit may consist of an area up to 1,200 square feet. I guess I don't understand, why that's necessary. I'm thinking of somebody who owns a large home, and it's a parent who, a single parent now living, a widow, for example, living in a large home, and she wants to invite her married daughter and her 2 children to come and live, but they want separate units. The house could be, 4,000 square feet, and Alderman Clemens talked about making it a duplex, but even without making it a duplex, if one of the units is a smaller unit in the building and then the other unit, is larger, or if they're both equal, but exceed the 1,200, requiring them to go before the zoning board to show hardship to get a variance, doesn't seem fair to me, and I'm not sure why you're limiting it to the 1,200, and what problem are you trying to solve, and are you creating different problems that, unnecessary.
Director Sullivan, or does Alderman Clemmons also, you want to add on to that, or?
That's a great question, and I think I need to think about that, Alderman Jettie. I mean, I think we have to remember first that, or I guess I'm remembering first, that scenario you've laid out makes a lot of sense to me, and I don't think there should be really any restriction. But our ordinance cannot contemplate whether the ADU is being occupied by a family member or non-family member. And so I think the question is, at what point are you functionally creating a duplex arrangement within a single-family home? And maybe that's okay. I mean, maybe this committee, this board feels that duplexes by right are something else that should be discussed across the city, but I think our goal there was to look at the average single-family home size and come up with a reasonable maximum square footage that would still keep the unit size accessory in nature. But I think that's another one that I should come back with a more thorough response on, because I think if you were to ask me why 1,200 square feet, Alderman Jettie, I don't know that I can answer that question well. So I think it's worth me getting more insight from the team as to why they came up with that number. But I do think whatever we come up with has to work in the scenario that you've just discussed, and it also has to work in a scenario where, a family of 3 is occupying the accessory dwelling unit and are fully allowed to do so, or 3 unrelated individuals are occupying the accessory dwelling unit, and it's in an existing single-family home neighborhood. Should the size of that unit be limited? And I think that's what we were attempting to do here. But let me get you more of an answer. I'm just thinking out loud in front of the committee and probably shouldn't be doing that.
Thank you, Director Sullivan. Alderman Clemmons.
Personally, I like it because I think what it does is it strikes a balance between what the state has contemplated, and it strikes a balance between the concerns that Mr. Richardson brought up, which is, are we just going to allow every single house everywhere to have one of these without going through some sort of process? I think it's reasonable to say that 1,200 square feet, okay, if you're in the 1,200 square feet, go ahead, you can do it, right? It kind of meets the spirit of the intention of the law from the state. But I think if you're going over that, yeah, you should have to go make your case in front of the zoning board and decide, and they should be able to decide whether or not it fits the character of the neighborhood. And I think, and we have the zoning variant signs out there, your neighbors would be able to know. I think it's a good thing. I think it strikes the balance of compromise. And so I don't have a problem with it. I think it should remain the way that it is in the ordinance.
Alderman Jettie.
So I would just like to, I hear what you're saying, and I'd just like to remind you that when you talk about going before the zoning board for a variance, and you talk about how, the zoning board would have to make sure it's consistent with the neighborhood. So you remember, variances have 5 specific requirements, and one of them, and the most difficult to meet, is the hardship. And the hardship has been defined as, not being, a poor widow who needs income. A hardship has to be, there's something unique about this particular property which makes it different than other properties in the neighborhood. So, if you've got a neighborhood of, of large houses, they're all similar situated. There's no hardship. I suppose somebody could probably prove a hardship, but it's not that easy. And it's you have to show that your property, the typical law school example is you've got a pie-shaped lot, and so now the setback requirements don't work very well for you because it's a pie-shaped lot and you've got a rectangular house, and so that can be a hardship. but just, saying that, somebody is needs extra income, or they have a family that needs a place to stay, that type of hardship is not what's contemplated by the law when you're talking about variances. So, it's different than a special exception where you just, you just have to show that it's not out of character with the neighborhood.
Thank you. One last point I can make, hopefully it's the last point, but one other thing that this benefits is the small business developer, because these aren't great big builds are going to happen. This is like a local builder, general contractor, who's going to have these opportunities to expand their business through the use of the changes to the ADUs. So it's another benefit to more working class, stable housing options in the city as well. So with that, all those in favor, say aye.
Aye.
All those opposed? The ayes have it. And Director Sullivan, you'll get us the answers, please.
We also have O-25-077, amending the land use code regarding unrelated households. I'd like to recommend final passage.
Discussion, Alderman Clemmons.
Yeah, I do have questions on this, and it's in related to the table 16.1. And my question is, in here, there's things listed like bed and breakfast, rooming, boarding, nursing homes, elderly housing, fraternity or sorority, things like that. Is there another section in the code that does have occupancy limits for those, for example, bed and breakfast or elderly housing?
Director Sullivan.
I'm going to confirm on elderly housing in just a second, Alderman Clemmons, but there's no further restriction of occupancy relative to bed and breakfasts that I'm aware of. We don't further stipulate square footage anywhere else that I'm aware of within the code. I'll confirm elderly housing in just a minute because we do have a set of supplemental use regulations that refer to that use, but I'm not aware of anything related to bed and breakfasts or any of the other uses on this table that might sort of fall into that category as well. I'm not aware of any such restrictions.
Your follow-up?
Yeah, I'm not going to support the way that this is. I'm not going to support this tonight because I do believe that when you have for all intents and purposes, a business which is offering units to the public to rent, right? So that would be a nursing home, that could be a dormitory because it's a college, right? That could be a rooming house, it could be a bed and breakfast, things of that nature where it's a commercial property, and anything that has more than 4 units is considered a commercial property, at least in Nashua, New Hampshire. So I think we do need to put limits on the occupancy of those types of places because they're a business. And I think that it would serve the public right for us to figure out what that limit is. If it's, I understand, if it's a single family house, if it's a duplex, an apartment, an ADU, basically a private residence, if it's below that 4 unit mark, fine. We can leave it out of the code, it doesn't pass state law. But if it's above that, I think we should try to figure out what it is that we as a community have a standard on for how many people per square foot we should have in those places. Because it's not like these folks are not gonna know, and while I don't wanna limit like families and things like that, right, to rent an apartment or something, I think we need to think about other situations, like the nursing home, or like a dormitory, or things like that. So I think there's a larger discussion here that needs to be really like fine-tuned for us to be able to move forward with legislation that really does what we want it to do on the many different scenarios that exist out there. I think eliminating this completely, while I understand that, you know, all it's doing is getting us in line with the state, I just think that I don't want this to be lost down the line, this discussion to be lost down the line because we pass this and then forget about it, or we pass this and it's not a priority to the administration anymore. I think, and not to say that it wouldn't be, but I'm just saying, because people are busy and because there are other more important things going on, I would prefer not to pass this and instead try to figure out what it is, which types of property we want to restrict, and get that into the code. We do it for hotels, right? You can only have so many people in a hotel. I think we should really think about our nursing homes, we should think about our dormitories, we should think about things like that.
Director Sullivan?
Alderman Clemmons is raising a point that I think some of us thought about when we were actually drafting this legislation, and that is that the line between what the statutory change said or called dwelling units, residential dwelling units, and what is a commercial use that's residential is a little bit murky. And so Alderman Clemmons, I think we took a broad approach here, but I think we could work to try and narrow that approach a little bit. What I would say is that we are fairly adamant that single-family dwellings, duplex or townhouse, apartments, and elderly housing are required to be removed from this table because they are true, pure residential uses, and we cannot restrict occupancy within those. I would agree generally that for bed and breakfasts, rooming houses, dormitories, fraternities, potentially, and nursing homes, they cross a line of being quasi-commercial, quasi-residential, and there may be some ability to further restrict. I will just note that within our ordinance, we do have supplemental use standards for bed and breakfasts where we restrict the number of uses, or sorry, the number of rooms. We have a tiered system that says certain numbers of rooms are allowed in certain contexts. We don't restrict occupancy, but we do restrict the size of the B&B. So I guess where I'm landing on this, unlike with ADUs, where I think we can address the committee's concerns on ADUs, we can go back over the coming weeks and have a conversation about whether or not some of these uses could be reclassified out of that residential dwelling unit category and produce an amendment to this legislation that might address that concern. I've just been texting with Manager Durfee, and I think we're in agreement with your concern, and we'd welcome some additional time to come back to the committee to maybe present an alternative strategy to address that. It's possible we'll come back and say, for this reason or that reason, we don't think we can do that, but I think we should at least explore that option, and we did have some discussion at the staff level.
And staff follow-up, and then Alderman Tebow.
Yeah, so my only follow-up would be, obviously, you know, I would not be looking for, you know, the unrelated part, right? This would just
Right.
be
Across the
how many
board.
people per square feet, right? And, you know, I don't know, base it on a fire code, I guess.
You could.
And
Yep.
and kind of, you know, use that as our standard and come back for these commercial properties that fit into these areas that are quasi-residential, and that's what I guess would be my ask.
Okay.
So I appreciate
I think we
that.
can do that, yeah.
Alderman Tebow.
Thank you. You know, I tend to agree with what Alderman Clemmons said. I mean, I don't want to be stacking up grannies either. The thing that you said about murky, if something is murky and if we think we can have some control in there, I say we take that control, because if they're going to leave it that way, murky, then we decide as the city how that should be done. And I know some of those other things are very specific in some of their the statutes. But if this isn't defined and we can define it, I say we do that. Because, when the state doesn't give you, you got to make the rule, right? And I think if you're saying this is murky and this is something we can actually, my question before you kind of answered Alderman Clemmons was, what tweaks can we make to what's here compared to the other ones where there were some things we couldn't do, except for like square footage and stuff like that. So if we can actually do this, I say let's work on that and do it. And I probably wouldn't support it tonight either, and hope to have something stronger with those particular things.
Okay.
Thank you.
Alderman Govea?
I was going to make a motion.
Can
Nobody
I add
else? Yep.
something?
Anybody, yeah.
Oh, and Alderman Jennings. Those people up at the State House just taking over local control and removing our ability to govern is very difficult. I just don't understand the philosophy behind those politics. Alderman Jettie.
So I heard you say that when it comes to residential, single-family residential homes,
Yes.
there's nothing we can do to restrict the number of occupants?
You certainly can. You can establish across the board occupancy limitations in any residential use. It simply can't be different based on familial relationship or any other status as defined in the statute. So you could say we shall have no more than one individual per 500 square feet in any residential use across the city of Nashua. I think what I was suggesting, Alderman Jettie, is, and I'm not saying you're suggesting this either, but I would be very cautious doing that because we have a lot of arguably very reasonable and acceptable living solutions around the city that would likely violate any such restriction. So I think you absolutely can, though. There's no question you just can't change how you treat family versus non-family.
So I guess the problem you're alluding to is, somebody might think, we don't want to allow a single-family home to be occupied by 20 unrelated people, but, if you have a family there that starts out with 2 people and they keep multiplying, each year they add another person, it's hard to say you can't have any more children, or if you have another child, you got to move. I guess that's what somebody is alluding to, I guess.
Director Sullivan.
I think that's right. I mean, that's an extreme example, but I do think, I brought up the example earlier because I know folks who have been in this situation where folks are renting a 900 square foot apartment or a 750 square foot apartment. You have a young couple and they have a child and they technically exceed that limitation. I mean, I think we all know people who've been in that scenario where they've lived in a small apartment and started a family.
950 square feet.
Right.
In a house.
And
Three
units
children.
are small, even smaller now. And so it's just, I don't think that's what any of you are trying to regulate, right? Or even Manager Durfee and I were chatting today, and he brought up a 2,000 square foot home. You remember we had talked about a 600 square foot limitation in this chamber and some committees. If you have a 2,000 square foot home and you have 2 adults and 2 children, you violate a 600 square foot requirement. So it depends, it depends. And different cultures feel comfortable in different densities of living. It's really hard to regulate. And I also, from an affordable housing perspective, and this gets thrown out a lot, but it's real, like you have young adults that are living in fairly dense environments as well, renting individual bedrooms within apartments. And I don't think any of you want to restrict that. I think what you're trying to get at is real clear overcrowding. And that's a tricky thing to grab, but I think in commercial settings, we certainly can regulate that. But in residential, I think it's a slippery slope.
I think generational housing is here to stay.
Yep.
I grew up in that, and my family still lives in that generational type living because of affordability issues. But again, the ADUs help solve part of that problem if people can afford to build and shift a generation into the detached or attached unit. These are some pieces of relief. getting to the nuance of it is practical, of course, so we'll look for a motion from Alderman Govea.
So I'm hearing we want a table. Is there
Yes.
anybody else who wants to talk?
Table would be great.
All right, I'll move the table.
All those in favor say aye.
Aye.
All those opposed? All right, we'll bring this back on the next PDC meeting before the Christmas break and after I return from Washington State. Alderman Clemmons.
Mr. Chair, and maybe I probably should have mentioned this while we were
Oh,
discussing it. but-
general discussion.
Okay,
There we go, go ahead.
so,
Nothing tabled in committee.
we may want to look at the calendar too, because if we make a substantial change to this, it's gonna
the
require
public
another
hearing.
public hearing. So, I would just look at the calendar and,
we've done this, but where I can be out of state and Alderman Govea can chair if we needed to make it earlier.
And-
I don't know what his holiday plans are, but,
And
or yours for, and such, but.
and I would just also say that we are aboard until that first Sunday in January, so don't forget, January 2nd and 3rd, which I believe are, I could be wrong, but I think it's a Thursday and Friday.
I've been telling everyone December 31st, my term ends.
Friday
I think that's on the website, too.
No, it's not, though. It's till the next inauguration, and we've had business like that when the inauguration falls, so I just wanted to capture that day into the conversation as well.
And if folks-
Because if we can do something.
Sure.
Yeah, I appreciate that. And if folks are on vacation or have requests this month and the very couple days of January, please let me know. I only have something planned at the start of December. Everything else I'm local for.
So my mistake, it's actually January 1st is Thursday, January 2nd is a Friday, January 3rd is Saturday, but,
So the 2nd would be the,
so maybe the Friday if we're all around, I'm just throwing it out there.
worst case. All right, public comment or any other general discussion? All right, public comment? Remarks by Alderman? None? Alderman Govea?
I move to adjourn.
That's in order. All those in favor say aye.
Aye.
The ayes have it, and I'll declare the meeting of PDC closed at 9:02 PM. Have a good holiday.
Man, you still want to catch up?
Yeah.